Welcome to this bite-sized training session hosted by Farrar Building. My name is Kamran Khan and I'll be spending the next 10 to 15 minutes discussing the basic principles of drafting a particulars of claim. In terms of looking at the purpose of the particulars of claim, we want to understand precisely what it is that somebody seeks to achieve when drafting them. Aside, of course, from the fact that it is a procedural requirement in order to partake in litigation, there are other useful reasons as to what a particularly good set of particulars of claim seeks to achieve. It helps you establish the parameters of your case. It is, in fact, a good exercise for those when considering whether that they have or considering the merits of their particular claim to see what the parameters of them are. It is important when drafting the particulars to identify the relevant issues, as well as that, any relevant documents that may well support your case in that regard. Once that is all done and the claimant effectively has its own house in order, it's been able to establish the parameters of the case and it can see that it has prospects in that case. What it also does is it enables the defendant or defendants, depending on who this claim is made out against, to understand what exactly the case is against them and what the claimant is seeking to pursue in that regard. We then move on to what it is that the claimant ought to include in their particulars of claim. Paragraph or CPR 16.4 does provide a set of detailed requirements as to what is needed in a particulars of claim. CPR 16, generally speaking, deals with statements of case. Looking at CPR 16.4, in terms of a requirement for a particulars of claim, what is required is a concise statement of the facts, the nature of the damages sought, whether interest is being claimed, and a statement of truth so that the claimant can verify that it has an honestly held belief in what's being stated there. There are other provisions to be aware of. No doubt those of you who are watching this may well be dealing with quite a lot of work in personal injury and credit hire, for example. Practice Direction 16 is particularly helpful and useful in that regard. You can see on the screen there, I have listed some of the relevant parts of that practice direction, which provides details as to what is required. For example, in relation to personal injury claims, there will be requirements as to including the claimant's date of birth, the type of injuries that have been sustained, what type of medical evidence is being relied upon. In respect of credit hire, this is a slightly newer addition to the CPR practice direction in that regard, and there are detailed requirements as to how to draft a statement of case in relation to credit hire, and in particular guidance is given on the issues that need to be covered, which no doubt many of you will have encountered before, and those pertain to enforceability, need, period, rate, and impecuniosity. As you can see, given the details that have been included within the practice directions, it is all designed to make or assist claimants in particular in ensuring that their claim is clearly pleaded and precise, and that has a benefit not only to the claimant in terms of how they advance their case, but of course to other parties in understanding what it is that they have to meet. Looking at the type of information required prior to drafting the particulars of claim, it is particularly important to ensure that you as a claimant or the representative of a claimant obtain the correct name of the party who you wish to sue. Not only that, it's important to understand what the relationship is between the parties. For example, are you as a claimant or a representative of a claimant looking to sue an employee? Or perhaps, and what is more typically done, are you looking to sue the employer who has the employee under contract? Once you get those, what appears to be very basic things right, it makes the claimant's route to establishing its case a lot clearer and a lot more straightforward, at least in terms of the basics. It's important to have a think about what exactly the remedy is that is being sought, and that should be made clear on the face of the particulars of claim and any corresponding schedule of loss. The estimated value of the claim, particularly when looking at personal injury litigation, is required by the practice directions. And of course, it's often something that falls by the wayside and then becomes a bit more problematic later on. But it is particularly important to understand or to ascertain whether there are any limitation issues. Hopefully there aren't any, but if there are, then further action needs to be taken. Looking at some drafting tips, there is no exact science when it comes to drafting particulars of claim. All I can say, and my best advice in relation to this, is to draft the pleadings with clarity and precision. This isn't an exercise which requires flowery language. All it requires is for the claimant to be direct and to the point in terms of what he or she is pleading and what he or she is seeking to claim. A well-drafted particulars of claim, one that details the particulars properly and clearly, is beneficial in the long run, because then there are further costs that are avoided going down the line in terms of the defendant asking further questions as to for the claimant to clarify its case, or in terms of the claimant having to subsequently amend its particulars for a lack of clarity, and so on and so forth. At this particular stage, it is also useful to think about whether one's case can be pleaded in the alternative. And in doing so, what that does is that it gives the claimant a greater chance of succeeding on its case, if not through one particular legal avenue, but another. Commonly pleaded cases in the alternative may well be one where negligence is alleged and ordinary common law negligence is pleaded. But if this happens on, for example, a private property where the claimant was allowed to be in as a visitor, then it makes sense to also plead the Occupiers Liability Act in the alternative. What we're going to do now is take a look at an exemplar particulars of claim. And in this particular example, it's going to be a personal injury accident arising out of a road traffic accident. And this is the start of the particulars of claim. You can see at the top that the particular court is mentioned and the case number is also mentioned. If it hasn't been made particularly obvious yet, then this is of course entirely fictional and is simply used for illustrative purposes. Here we have a claim by Miss Jane Doe against Big Buses Limited, and you can see in the tram lines it's marked very clearly that these are the particulars of claim. Of course, the first thing that one does when drafting the particulars of claim is setting out the facts. As I mentioned earlier, where you can be as precise and detailed as possible, then by all means, please do so. And what you can see in terms of a basic structure, the paragraph 1 deals with when the accident happened, what time the accident happened, and where it happened. These are all key details which no doubt in a good case for the claimant will be corresponded in corroborated in the witness statement that comes at a subsequent stage. Paragraphs 2 and 3 effectively set out in further detail what the claimant believes happened on that particular day. On this occasion, the claimant's allegation is that the driver was driving his vehicle, so that you would insert the vehicle make there, as well as the registration number in the course of his employment with the defendant, and drove into collision with the claimant as she was crossing the road. And the claimant's subsequent allegation is that the defendant, i.e. the company, is vicariously liable for the negligence of their employee, who is, in this particular case, Mr. Bus Driver. The next step then is to particularize how exactly the claimant believes that the defendant was negligent in that regard. And you can see the particulars of negligence are set out there. There are a number of allegations here by the claimant that the bus driver was negligent in a whole number of ways. For example, he drove too fast in the circumstances, failed to give any sufficient warning of his presence, and also that he failed to sound his horn. This section is particularly important from a claimant's perspective in ensuring that all the particulars of negligence in this case, or whatever the cause of action may be, are set out in clear terms. And as mentioned before, it's such that the claimant can show that it has a robust case against the defendant, and from the defendant's perspective, such that the defendant is aware of exactly what the case is against it. The next section deals with the particulars of injury. So this goes back to what it is exactly that the claimant is looking for as a result of the accident and as a result of what they are claiming for. And you can see in terms of the particulars of injury, there is a brief explanation at paragraph 6 that the claimant is a student. He or she was born on date X, and where they sustained injuries. And in support of that, the claimant should have with them a medical report or subsequent number of medical reports which have been prepared by whichever doctors have prepared them in this case. It's important that all that detail is included there and is then attached alongside the particulars of claim. You can see as well at paragraph 7, the claimant has pleaded its entitlement to interest. It's important to plead that as a matter of good practice. And ultimately, paragraph 8 shows that the claimant has complied with the various different practice directions. And in summary, we can see what is being claimed. That there is a personal injury claim here that's in excess of £1,000. Interest will also be sought, and costs in the event that the claimant is successful. That is effectively a whistle-stop tour in terms of drafting particulars of claim. The principles are relatively basic, but the devil is in the detail, and it's particularly important how one sets about drafting the particulars. It is about ensuring that they are clear, precise, and easy to read for the defendant or defendants, as well as the court, because ultimately the court will be making a decision as to where the liability and the causation aspect of this fictional claim here lies. I hope you found this session useful. Please do refer to our knowledge-based section on the Farrar's Building website for further bite-sized training if you have found this particularly helpful. If you would like further in-depth or more personalised training, please don't hesitate to contact our practice manager, and no doubt we will be able to accommodate you and cater to the particular training that you wish to undertake. Other than that, I just want to say thank you very much for your time, and once again I hope you did find this useful. And as you can see on the screen, my contact details are below, so please do feel free to contact me should you need anything.